The title of today's topic is Judicial Approach to Protection of Prisoners' Rights. Let us have some introduction. One of the fundamental tenets of human rights law is that human rights are inalienable and universal. Human rights are meant for all human beings. The Universal Declaration of Human Rights under Article 5 provides that no one shall be subject to torture or cruel, inhuman or degrading treatment or punishment. Similarly, the International Covenant on Civil and Political Rights, also under Article 10, clearly states that all persons deprived of their liberty shall be treated with humanity and with respect for inherent dignity of the human person. The Constitution of India contains various provisions relating to human rights. The most fundamental human rights recognized by our Constitution is the right to life and personal liberty as provided under Article 21, which states that no person shall be deprived of his life or personal liberty except according to procedure established by law. The constitutional premise of liberty is whether inside or outside, a person should not be deprived of his freedoms save by methods right, just and fair. The fundamental human rights enshrined in Part 3 of the Constitution have been made non-derogatable by virtue of Article 13 Clause 2 and their enforcement has been made a fundamental right under Article 32. The judiciary, particularly the Supreme Court of India, has thus a constitutional obligation to protect human rights of every person, including prisoners. Prisoners do not, by mere reason of imprisonment, lose all the fundamental rights which they otherwise possess. Prisoners are entitled to all constitutional and other legal rights available to free persons, save those which have been constitutionally curtailed or are incapable of enjoyment by reason of imprisonment. The fundamental rights do not flee a person, even if he is sent to prison, though he may suffer some sickness because of imprisonment. A prisoner is no longer regarded as an object or a slave of the state, and he does not cease to be a person just because he has become a prisoner. Prison authorities cannot inflict additional punishment to a prisoner without proper sanction of the courts. The Supreme Court of India as well as state high courts as constitutional courts have been very active in protecting human rights of prisoners. The Supreme Court has given a liberal and comprehensive meaning to life and personal liberty enshrined in Article 21 of the Constitution for the preservation and protection of prisoners' rights. The Supreme Court of India has widened the scope of Article 21 in its endeavor to zealously protecting rights of prisoners and even went on for prison reforms for protection of rights of prisoners. Now we will discuss judiciary and human rights of prisoners. Higher judiciary in every country has a constitutional obligation to protect the rights of every citizen, including prisoners. The Apex Court of India has been able to recognize a number of rights of prisoners even though they do not find in statute books. The role of The Supreme Court, in recognizing and protection of rights of prisoners through various judgments, has been a milestone in the judicial history of the country. The various landmark judgments of the Constitutional Court relating to recognition and protection of prisoners' rights are discussed under different headings. Number 1. Rights against solitary confinement and bar fetters. Imprisonment did not reduce a person into a non-person. In the case of Sunil Batra versus Delhi administration, the Supreme Court held that solitary confinement of prisoners was highly degrading and dehumanizing effect on the prisoners. Such confinement could be imposed only in exceptional cases where the prisoner was of such a dangerous character that he must be segregated from other prisoners. A prisoner under the sentence of death can be inflicted and impose solitary confinement only in view of the safety of the prisoner and the security of the prison. Such a prisoner might be kept in separate cell only after the sentence become executable. But even in the separate cell, unless there were special circumstances, he must be kept within the sight and sound of other prisoners and be able to take food in their company. The court also held that continuous keeping of a prisoner in fetters day and night had reduced the prisoner from human being to an animal, and such treatment was so cruel and unusual that the use of bar fetters was against the spirit of the Constitution of India. Secondly, right against handcuffing. The Supreme Court was also of the view that routine handcuffing culture of prisoners is prima facie inhuman and therefore unreasonable. The apex court held in Prem Shankar versus Delhi administration that handcuffing of a prisoner without adequate reasons in writing is against constitutional mandate of Article 21 and thus ban the routine handcuffing of prisoners. Thirdly, right to legal aid. Majority of prisoners in the country are poor and unaware of law. They are underrepresented by competent lawyers because of poverty and legal illiteracy, and as such, their rights are not properly protected. The Constitution also does not expressly provide the right to legal aid, but the judiciary has recognized this important right to provide free legal services to poor and needy prisoners to defend themselves. The Supreme Court in the case of M.H. Hoskot versus State of Maharashtra held that right to free legal aid at the cost of the state to an accused who cannot afford legal services for reasons of poverty, indigence or incommunicado situation is part of fair, just and reasonable procedure under Article 21. Further, the trial court is under an obligation to inform an accused who fails to afford legal representation that he is entitled as of right to be represented by a lawyer of his choice at the cost of the state. Further, in Sila versus State of Maharashtra, the Supreme Court held that a prisoner, whether under trial or convict, has a right to legal assistance and that must be made available in jails. Fourthly, right to speedy trial. The right to speedy trial has become a universally recognized human right. One of the basic objectives of criminal justice system is to punish guilty persons and innocent persons are not harassed. It is an important duty of the courts to see that justice is not delayed and the accused persons are not indefinitely detained in prison. In the case of Hussain-Ara Khatun versus Home Secretary Bihar, the Supreme Court has held that although the right to speedy trial is not specifically mentioned as a fundamental right, it is implicit in the broad sweep and content of Article 21 of the Constitution. The Apex Court also held in the case of HRL&CJ versus R.S. Nayak that the right to speedy trial flowing from Article 21 is available to accused at all stages such as investigation, inquiry, trial, appeal, revision and retrial. Fifthly, right to have interview with relatives, friends and lawyer. The judiciary has been upholding various rights of prisoners. The Supreme Court has categorically opined that the expression personal liberty in Article 21 is of widest amplitude and it covers varieties of rights which go to constitute the personal liberty of man. In a series of cases, the Apex Court has considered the scope of the right of prisoners to have interviews with family members, friends and counsel. In the case of Francis Kwarali versus Union Territory of Delhi, the Supreme Court held that personal liberty includes right to have interview with family members and friends as well as with the lawyer, subject to search, discipline and other security reasons. Upholding the right, the Supreme Court in the case of Dharamveer versus State of UP has directed the state government to allow family members to visit the prisoners and for the prisoners at least once a year to visit their families under guarded conditions. Sixthly, right to write book. A prisoner does not cease to be a human being incapable of having fundamental rights. In the case of State of Maharashtra versus Prabhakar Pandurang, the Supreme Court held that the right to personal liberty included the right to write a book and get it published, and when this right was exercised by a detainee, its denial without the authority of law violated Article 21. Seventhly, right against narcoanalysis, polygraph, brain mapping tests. Recently, the Supreme Court has been very sensitive to recognizing rights of prisoners not only to protect them from physical discomfort or torture in person, but also to save from mental atrocity. With the advancement of technology coupled with neurology, narcoanalysis, polygraph tests and brain mapping emerge as convenient tools of investigating agencies for eliciting truth from the accused persons. However, these tests are opposed by human rights organizations as atrocity to human mind, breach of right to privacy, as well as violation of right against self-incrimination guaranteed under Article 20, Clause 3 of the Constitution. In Salvi versus State of Karnataka, the Supreme Court has accepted voices of dissent against such tests and has declared narco-analysis, polygraph tests, and brain mapping unconstitutional and a violation of human rights. But the court also added that a person can only be subjected to such tests when he assents to them. The results of tests will not be admissible as evidence in the court, but can only be used for furtherance of investigation. Now coming to judiciary and prison administration. Besides recognizing and protecting rights of prisoners, the Supreme Court has also issued various directions to eradicate the unhealthy atmosphere in prisons. Some of the important directions are mentioned hereunder. Number 1, district magistrates and session judges should personally or through surrogates visit prisons in their jurisdiction and afford effective opportunities to the prisoners for ventilating their grievances and should make expeditious inquiries therein and take suitable remedial action. Number 2, the prisoners' rights should be protected by the court by its writ jurisdiction plus contempt power. To make this jurisdiction viable, free legal services to the prisoners should be promoted by professional organizations recognized by the courts. Number 3, large notice boards displaying the rights and responsibilities of prisoners should be hung up in prominent places within the prison in the language of the people. Number 4, the state should take steps to keep up the standard minimum rules for the treatment of prisoners recommended by the United Nations, especially those relating to work and wages, treatment with dignity, community contact, and correctional strategies. Number 5, the prison officials should send directly to the court petitions made to them by the prisoners from within the prison instead of routing them through the higher authorities. Number 6, if a prison administration takes any legal step which further affects the personal liberty of a prisoner, it should observe the principles of natural justice which are part of fair procedure established by law. Now let us come to conclusion. The judicial trend in protection of rights of prisoners is very encouraging, and the Indian Supreme Court has played an important role in expanding the horizon of human rights of prisoners. A prisoner is no longer regarded as an object or a slave of the state, and he does not cease to be a person just because he has become a prisoner. A prisoner has all the fundamental rights and other legal rights available to a free person, save those which are incapable of enjoyment by reason of imprisonment. The Supreme Court of India in various cases has taken a serious note of the inhuman treatment on prisoners and has issued necessary directions to prison authorities for safeguarding the rights of the prisoners. The court also emphasized that the discretion vested in prison administration is to be exercised in a fair and reasonable manner without violating the rights of prisoners. It is submitted that the prison personnel should be made aware that a prisoner is not denuded of his basic human rights merely because of imprisonment, for which they should be given regular training on the subject of basic human rights of prisoners. Thank you.